Rise and shine. Pour yourself a cup of coffee and tune in to Good Morning Aurora. News, weather, and really cool interviews. Monday through Friday from 8 to 9 a.m.
Good morning, Aurora. Good morning, Aurora. Good morning, Aurora. The time is now 7:32 a.m. You're listening to Good Morning Aurora, second largest city's first daily news podcast, and we've got a special episode for you guys today. Due to a lot of the consternation and lack of knowledge behind the Reform Bill HB3653, we reached out to a couple of friends of ours in law enforcement, State's Attorney Jamie Mosser and Kane County Sheriff Ron Hain. Both of them come on to talk to us about HB3653, what it is that law enforcement objects to and what it is that law enforcement supports. This is very important because although the bill has been named bad by its detractors, it's actually not to those who support police reform, and for many people who do see it as the best thing since plastic bags for pickles, there's still a lot to be desired, and that comes directly from our friends in the law enforcement community. So what we try to do in this episode is we present just the facts. We are glad to be able to sit down with State's Attorney Mosser and Sheriff Hain to discuss the bill and see what they like about it and what they don't like about it. Some of the topics that we will be talking about are collective bargaining, detainee rights, and the system that will allow for complaints to be filed against officers. So I think it's literally called like the complaint system. Those are some items that we'll be talking about. We'll also be talking about decertification, so pretty much all of those topics that are points of concern to law enforcement in the bill. For our friends in the social justice community, we encourage you to listen in, and for our friends in the law enforcement community, we encourage you to listen in as well. This video that you will be watching was conducted live. It is here for you in its entirety. Nothing has been changed, added, or taken away. It's very good. It's full of information that you guys need, and it is factual, it's relevant, it's pertinent, and it's important. And we hope that you guys enjoy it. Don't forget to check out the show on Spotify, Good Morning Aurora, iTunes, Google Podcasts, or any other platform that you listen to your podcasts on. We're proud to be the second largest city's first daily news program. So, real quick before we go, quick shout outs. I want to say shouts out to our friends Jen Ingram Art, Cottonseed Creative Exchange, Visual Arts, Windy City Game Theater, Aurora Business United, Double A Electric, or All A Electric. So many great businesses and so many great things happening in the city. Presidential Cleaning Services as well. Big shouts out. And shouts out to all of our friends out there in St. Charles, Geneva, Elgin, Batavia, Wheaton, Wilmette, Chicago, North Aurora, Montgomery, Yorkville, and Caneville. And that's the news. So I think a good thing to do first would be to let the folks know who you guys are and what you represent. So we'll start with you, Jamie.
Perfect. So I am the newly elected Kane County State's Attorney. I took the office on December 1st and have hit the ground running since then.
Very cool, very cool.
I am the not so newly elected. Been in office for just over 2 years now, so that's still pretty fresh.
Right.
But we are very focused and dialed in amongst all the other things we have to worry about on a daily basis, but this one is adding a whole new matrix to our minds.
Right. And for those that know, or for those that may not know, HB 3653 has not yet been signed into law.
Correct.
Okay, so it's currently awaiting the governor's signature.
Yes.
There are things, the general impression that I and people have is that there's things that you guys like about the bill and things that you strongly object to. So to start off with, what do you object to about the bill?
So before I get to the objections,
Okay.
because I think we go negative right away.
We got a lot to talk about.
This is like her going on trial right here, right?
This is, here's my opening statement.
Right.
So I am in favor of the reform that's in this. And so part of the problem that I think we had in the beginning is I'm a terrible politician. I've never been a politician, and I don't understand that whole process. I don't understand how you propose something and then it gets approved and then it gets edited later.
Sure.
I'm also an attorney, so for me, knowing that somebody voted on something that gets changed later is a foreign concept to me. So I've learned more about this, and so this actual bill and what is in here has actually been discussed over hundreds of hours. The Black Caucus has put this forward trying to get this reform for a long time,
Right.
and it's mostly fallen on deaf ears. And this is something that I found out as we went through the process and we started to learn this.
Right.
And so what they did is they used a political strategy to get this through quickly so that we can get to reform. And while it's not the way that we work in terms of our criminal justice system, it's a way that now we're actually going to get the reform that we desperately need. And so the reason why we are so vocal about this is because we want to be a part of the process now, making sure that the language does what it's supposed to do.
Okay.
And so from my perspective, the biggest thing that I objected to is some of the provisions about the pretrial release. So pretrial release is eliminating cash bail, and I know we're going to talk about that
Right.
later. The way that it ties the hands of the judges in who they can and cannot hold is my biggest objection in this, because it allows for people who are a danger to our community not to be held.
Okay. Right. Now, specifically the language.
Yes,
I think that you were harping on the language in many parts of that.
yes.
And Sheriff, is there a part, is there one nice little tidbit of it that you don't like, or what do you not like about the
Yeah, I don't want to get off your agenda at all, Curtis, but I would like to just chime in on the no cash bail. So we're both fans of the cashless bail system, okay? So let's get that right out and clear
Right.
ahead of the game. So that's one of the things that we're a proponent of in this bill. But there needs to be, besides the state's attorney's objections about what needs to happen at the preliminary hearing, or the pretrial petitions, or what is it, the
Bond hearing technically. So it's a pretrial release hearing. So somebody's arrested, they're taken into custody. The next day they come over to the courthouse, and that's what we typically call our bond or bail hearing.
Right.
Now it's going to be called a pretrial release hearing.
Okay.
But what is the petition you have to file?
A verified petition
There
to
it is.
hold a person.
Okay. Now, you didn't have to do that before.
No, so
Right.
what happens is, essentially, we get the paperwork an hour before court starts.
Okay.
And this is the synopsis of the event, it's the criminal history, and we go to court and we argue. This is why a person should have a certain amount of bond, or this is why a person should be released on recognizance, and these are the conditions that we're recommending. And then a judge decides based on the crime that's charged, the synopsis, the facts that make it so that we're going forward with the charge, and then the criminal history, and any prior failures to appear by a defendant in other cases.
Okay.
Yeah,
Okay.
so again, we could spend an hour talking about the cashless bail system.
And we have.
Yes,
Right.
just between us.
Yes.
But what also needs to happen, so if somebody is remanded to a sheriff's custody, which is what the judges can do now.
Right.
It's either, basically, you're gonna go to jail and sit, or you're gonna go back home. Okay, those are
Right.
the two options we have. So if you're gonna go to jail and sit, this bill doesn't say anything about what's happening inside that jail to try and correct your behavior. So what it's desperately missing is simple mechanics that every correctional institution should have in place to make sure that there's corrective behavior taught to the people while in custody.
Right.
There needs to be a structured system where there's an assessment every 1, 3, 6, 9 months, however long they remain in custody, to determine if this person should be eligible for some type of release. So we've talked about, I was on your show before talking about the programs we've instituted inside the Kane County Jail.
Right.
We now have a very structured, graduated system where if you are performing at high levels, you can finally make it to the golden zone, which is recovery pod.
Right.
And we make recommendations. I write letters. Heck, I've appeared in court on behalf of defendants. I know that's been
Much-
unpopular with some of your folks. However, they need to think out of the box and think critically. So, when I see somebody sitting in jail under a cash bail system right now, a black man who's been arrested maybe 3 or 4 times in his life, but who has a $500,000 bond because of his criminal history for 3 or 4 grams of heroin. Yes, heroin is horrible and we need to get it off the streets. But if he's sitting in my jail for 2 years just waiting for his trial at a $500,000 bond, but he's performing exemplary through all of our programs,
Right.
somebody's got to step up and say, folks, something's not right. Let's exit program this individual and see how he performs in the public.
Are there, if you can share, are there any people now who are a threat, who are incarcerated, who, if this bill was signed, what we're talking about, they would be able to be released without some of those? Is that a possibility?
It is, and I want to give you the example of multiple DUIs. So the way that this was written is if you have a forcible felony, or if you're non-probationable, so just because of the crime that you committed, like a murder, you're not eligible for probation. Those are the people that we can hold pre-trial.
Right.
Then they do other factors like domestic violence cases, stalking cases, gun cases, things like that, and those are also people we can hold. What it leaves out are other things. So a person who commits multiple DUIs. You can commit multiple DUIs and still be eligible for probation.
Why is that?
Because that's the way our law is written. Our law is written so that we have a gradual step up in terms of what happens. So the first DUI you commit, assuming there's no accident, you have a license, that's a Class A misdemeanor. And it's the right way because usually when you commit a DUI, it's because you've gone to the bar, you're drinking too much, and you make a bad decision.
Right.
So what we want to do, obviously, is be able to get you counseling and make sure that you never do this again. But as you commit more DUIs, then it goes up to a Class 4 felony. So it keeps going up, but it doesn't mean you're necessarily automatic prison on those cases. That's a person who, based on the language of what they put in here, a judge cannot hold them because there is no identified victim. We are all potential victims of that person because we're all driving. But the way the language is in here, we would have to list a victim that they're a danger to. Who is that person? Can Curtis, I put you down on every single one because you drive on our streets?
No.
That's the problem with this. They need to change the language for all of this to also say that they could be a danger to the community. Because a person who drives drunk multiple times is a danger to our community.
Okay. That's an excellent example.
Thank you.
So, if there's an individual, say this is signed into law, and an individual has a history, 5 DUIs, the second involved harming an individual, they were gravely wounded. If that person commits another DUI, and now is talking to the judge in the morning, is he going to be remanded into custody, or will he be let go?
So again, it depends on what he's charged with and if it's non-probationable.
Okay, because that's the thing. I think people, literally, criminals will be able to walk free, and I don't see justice turning that blind of an eye. So that's why.
Right, and that's what our objection is. What this has tried to do is to keep the people out of custody who shouldn't be.
Right.
So we've talked about this a lot. A person who commits retail theft, most of the time people are stealing for a reason. They're stealing sometimes because they don't have food on their table. They're stealing because they're trying to supplement a drug habit. They're stealing because they have mental health issues, and again, sometimes they're self-medicating, so they need that. So those are the people we don't want to keep in custody because we say you have a $500 bond, which technically means 10%, $50, and they don't even have the $50 imposed.
Right.
That's who we want to keep out, but we have the ability now to do that. But what Ron is saying that is the secondary portion to this person who has 3 or 4 grams of heroin that they're using, not dealing, using.
Right.
When they're in the system, they stay in the system because maybe their criminal history keeps them in there, but they're doing his programming.
Right.
And this is the thing I want to say. Our jail is an example to what everybody should do. And what we really want people to add into this language. Put this programming in jails so that people can do treatment while they're in there, but then have a mechanism in here where that's reviewed again by the judge and with the state's attorney's office to release that person to see how they're going to do when they're in the public.
Okay.
Let's get them the treatment. Let's give them the opportunity to see what they're going to do in society. And Ron is really big in regards to all of this. And let's see if we can stop them from continuing down this path of criminality by just putting them right back in jail or prison. That's what we don't want to do.
Here's the other safety net that needs to be in there. Guess who's in recovery pod? The majority of the offenders, multiple time DUI
Correct.
offenders and retail thefts. So the reason why retail thefts end up in there is just like Jamie said, many of them are addicted to something, typically heroin. And now finally, they're getting treatment while in custody. So what's gonna happen if those people are diverted from our jail and don't get that treatment? They're
Adding to the
going to
recidivism
go
rate.
right back out and reoffend.
Sure.
Yeah, that's
Sure.
what's gonna happen. So there needs to be, I don't care if it's not in custody, but a mandated referral reference in this bill to continued addiction support or counseling after that initial arrest. Yes, I get innocent until proven guilty, and that's really what this law is striving for when it comes to keeping people out until their trial occurs. However, there are so many people who are offending because we're just not providing them proper support in the community.
So this cash bill portion is, my words, is merely just not well thought out, basically, in the bill. Is that a fair assessment? It's just not.
I think what it is that there are so many nuances in our job that we know about, and we read this, and we panic, and we think this is terrible. When they wrote it, I'm trying to look at it from the perspective of the people who wrote it. They just don't know how we actually do it because they're not prosecutors. They're not police officers.
Right.
They're writing it with this, what I believe is an altruistic desire to really to really fix a bad system.
Right.
But they're doing it in a way that has these unintended consequences that we know because we're in the thick of it every day.
What's the benefit of having a cash bail system?
So, well,
Not just be
No.
good on what people don't like, but I mean, this is reality. What benefits are there?
I really don't. So the biggest benefit is it funds our court system. I mean, that's essentially it. But if you think about it, a person who's arrested and they post $1,000, 10% of it, no matter what, we dismiss the charges, they're found not guilty, 10% stays in the court system, and it funds a system that we've been using because frankly our county doesn't fund it in the way that it should or could. So that's the one benefit. The detriment to it is what's great, because again, we put this money on because we think the idea is that they're gonna come back because they don't wanna lose their money.
Right.
We have seen that that doesn't actually mean anything.
Yeah.
Because people don't come in for a variety of reasons. Sometimes people just forget. Sometimes people are like, nope, I'm never coming back. But if they lose their money, we're just perpetuating a cycle.
Right.
If we need to keep somebody in because they're a danger to the community, then we just keep that person in. As Ron said, sometimes we keep people in because they're a danger, they get treatment, and then we can release them at that point. I don't see any purpose of saying $500 is the reason why you stay in.
Yeah. Cash bail does give that autonomy to judges to hold somebody. You know, they place incredibly high bonds, $2 million on somebody who's arrested for an attempted murder or a murder or a shooting because they're a danger to the public. But then you do have the off balance of people with that criminal history in the background, or the retail theft example, which I love that you give. You know, your bond is $500, you got to pay $50 to get out. You can't even afford that.
Right.
So the other problem is the autonomy. Is that not every judge is going to assess an appropriate bond. So that's why we're fans of the cashless bail system, because it's either you're in, you're out, and here's number 3. I don't know if you're ready to segue yet, or you go on electronic monitoring.
That's a great, you know what, the time is now 8:29 a.m. You're listening to Good Morning Aurora, the second largest city's first daily news podcast. We are here with State's Attorney Jamie Monster and Sheriff Ron Hain. You know what, we got a lot. Good segue, let's put a pause on that. Damn, electronic monitoring. Because that's a great way to strengthen resources within departments, flesh out technology, and also stop recidivism. Hopefully, intervention when we can. Right. Because when you have electronic monitoring, you're dealing with a probation officer.
Well,
No.
yeah, here you're dealing with. Can I answer for once?
Yes,
This
you
one?
can, I'm sorry.
You know what Sarah said? Oh man.
Yeah, so,
Sharing the stage.
yeah, we're proud of this electronic monitoring thing. So the sheriff's office took over. I think we talked about it when I was on the show before. We took over electronic monitoring. I should say we rebuilt it in 2019. So Kane County defunded the program in 2018 when it was run by the Court Services Division. It was $750,000 annually to operate electronic monitoring. So of course, when you take that program away, where does everybody go? they have to go back into custody, right? They have to go back into jail. So it costs us, when I say us, taxpayers in Kane, $75 to $85 a day, depending on the needs of the individual, to keep them in custody, right? It costs me $3.95 a day to lease the ankle bracelet that goes on that individual, to release them into the community, to be back with their family, to put them to work, to put them through education, whatever they need to get a leg back up and be productive in the community, okay? So what is more beneficial? Locking somebody in a cage for average $80 a day, or get them back out through our diversion team and through our electronic monitoring team to go back to work and again, be at home and engage with their children?
Certainly the electronic monitoring is urgent.
Right. So people say, well, heck, that was $750,000 that you have to take on, Sheriff. And I say, no, if they're not in my custody, then I'm saving money within my jail food budget, my medical budget, my equipment budget, my salaries. So I am using, right now we're currently funding the entire program through the jail food budget. Because again, if I'm not paying to feed them, I can use that to put them back out on the streets.
Right.
So all of that said, we're actually saving, and we estimated over the course of the first year, if we were running at full capacity, which we're not yet, court services, they handled 80 to 120 people a day. Right now we have 35 as of today, and we keep pressing the courts to help us bolster this program. But yeah, we have the capacity to get back to that point, and we estimate if we are running at full capacity, we actually save the county almost $1 million annually by keeping 80 to 120 people out of our jail.
Question from the audience, is that $3.95 a day or $395?
$3.95.
That's a very good question.
Yes. Did I just say $3.95?
You said, yeah,
You did.
you left it like that. I was like, what the, thank you, shouts out.
I mean,
we got some great listeners, hang on.
Sometimes if people let, me speak first, that would have been clear.
Good shot.
Thank you.
You're gonna find me banter quite a bit.
A lot.
Okay, all right, yeah, this is the first time you've been on the show twice.
Yes.
Sheriff, you've been on only once before we were doing videos, so we're glad to have you guys both on at the same
She's
time.
been in office 2 months. I've been in office 2 years and twice?
This is her
during my
first
campaign.
Right, this is
Yes.
campaign time. All right, so that's cash bail, and we'll filter and have a couple of more questions. Yeah,
She's got a while.
I do have
She's got
one
alarming
point.
things
Sure.
for you.
Yes,
Electronic
here's
monitoring.
another alarming thing. So I'm a
Data?
huge
Oh, yeah.
fan of electronic home monitoring and GPS, especially because I came from the domestic violence world, where part of what we did is when a domestic abuser was released, we put that bracelet on them, then there would be a protected zone over where the victim lives, where the victim works. So the victim could live and go to work and not fear that the abuser is following her because of this.
Because it'll go off
Right.
once they breach that.
Yes.
Under this law, what happens if they cut it off?
Well,
They're monitoring bracelet.
48 hours. This is what this law says. The law says that if you escape electronic home monitoring, you cut your bracelet, and it is literally cutting your bracelet, you have 48 hours before we can charge you with the crime of escape.
Now that's not a provision now, correct?
Correct.
Okay.
If you cut your bracelet off, you've just committed the felony offense of escape, which means we can charge you with that. We're going out, you're going out, I'm sitting in my office still. He's going out and he's arresting that person because now they are doing something. Why would you cut your bracelet? You would cut your bracelet because you're going to do something. So think
Because
about
it's
a
itchy.
domestic, because it's itchy. A domestic violence victim now has 48 hours where we don't know where this person is. The community doesn't know where this person is because they've escaped. This law says we cannot charge you for 48 hours. You
Why
can
did they
come
make
back.
such a change?
I don't know. That's a fantastic question. Why are we giving you 48 hours to come back? Or more importantly, what are you doing during that 48-hour time
Sure,
period?
yeah.
Are
How
you
much-
sitting outside the victim's home?
How
Are
much
you
crime
following
can you
them?
commit in 47 hours and 59 minutes?
Oh,
it's,
yeah,
it's,
right.
it's open range.
Yeah.
It's alarming.
If this person didn't have a prior history of domestic and they were given this electronic home monitoring and now they've cut their bracelet and are now they're a threat now, I would think that would make that penalty harder and would eliminate the ability for people to do that and have runaway time.
Mhm.
So is that a blow that a stringent policy was now made lax?
Yes. Because what really then is the penalty for doing that?
Sure.
That defendant comes back around and says, I'm so sorry, can you put the bracelet back on?
Right.
Why? I mean, those are the questions that we want to sit down and talk to them about, because for us, that's a danger to our community, and that's a danger to the victims that I want to protect, that Ron wants to protect.
So that's electronic home monitoring and cash bail. I would like to talk about collective bargaining. Can we do that?
Sure.
For the record, what is collective bargaining for those that don't know?
Sure. I have five different collective bargaining units at the sheriff's office. So of course it's unionized employees, is simply what it is.
Okay.
Collective bargaining agreement is what they arrange with management for working conditions. So salary, wages, and I think that this bill is really trying to limit the disciplinary angles that are included in the collective bargaining agreement. Because again, this bill wants to structure discipline under the state and remove it from the actual management.
What's wrong with that?
So I don't necessarily completely object to the idea of citizen review boards. Those citizen review boards absolutely must be well-trained, well-qualified, and have a good working knowledge of the law and a good working knowledge of public safety.
I totally agree with you.
So what this bill represents is, again, taking that disciplinary discretion away from the law enforcement agency and placing it under the state. And really it's an attempt to, not even an attempt, it's an act to either certify, which happens right after the police academy, law enforcement officers are certified and you gotta take the test and you get your certificate.
Via the Illinois State Police.
Yes, well, the Illinois Law Enforcement Training and Standards Board
Okay.
structures all of that. And that's who is going to structure this new police review board, as we read it, that works in every region of the state. So they want this police review board to have the ability to go ahead and either certify, allow the certification to continue, suspend the certification, cancel the certification, postpone the certification. There's a bunch of different terminology in there in regards to what they can and can't do to disable the professional life of a police officer. So that is why the CBAs were discussed in this bill. It's basically removing that piece of power and putting it under the state.
What's the motivation, do you think, behind that? Again, was it just an idea that they thought was great, which is actually wrong, or was that a concerted effort to try to throw a monkey wrench into the law enforcement system?
So thinking altruistically, as you said, I think they just want
So
to
what are they?
build, yes, we just hope it's altruistic, that's all we hope. That they just want to structure an objective committee, if you will, to, again, decertify law enforcement officers should that need to happen. However, there is just not enough structure around who is going to be sitting on those review boards. I think that is going to be where the subjectivity comes into question. And you know, as we parlay into complaints against officers, which is the one I get the most heated about, when you read that part of this bill, I have 20-year police officers who are talking about retiring now, who wanted to serve another 5-10 years. I have new police officers who are going, well, Indiana's right there, Wisconsin's right there. Maybe I'll just leave here and go work in a state that's not gonna pass a bill like this. And recruitment, I mean, we're creating an environment and setting a tone, because we weren't at the table on this bill, where people are not going to want to be police officers in this state.
How can that, you know what, hold on. This is a lot of fun. This is a lot of fun. We'll briefly say, how can that be?
What?
Why would a person not want to be a police officer? Why would...
Can we talk about this is gonna segue into the complaints against law enforcement officers section of the...
No, we'll just let it segue. All right, fine.
I'm sorry, Chris. It's one big spider web.
No, it is. Okay, let's go into so for the record though, collective bargaining still, if this bill is passed, collective bargaining is still in the hands of police unions. Is that
Yes.
correct? Okay.
Yeah.
So
It's just
my
removing-
idea is the reason why they wanted to do this is they wanted bad cops just to not be able to get their jobs back. That I think is the altruistic thing behind this, because unions could fight. If a bad officer does something, a union could fight to keep that person, have that officer have their job back, and that has happened.
Oh, yeah.
A lot. They
It's
go from
incredibly difficult to
one
fire
place
officers.
to
It is.
another department. Yeah.
Correct, and to that end, I agree, and I think to that end, most police officers agree that they don't want bad cops to get their jobs back. And unfortunately, it has happened. But again, because of the way everything was written in the first bill. So this is here because this is the current bill. The first one that was put out was 611 pages. This is 764 pages. And we keep reading all of this stuff, and I have notes about it. They changed it from the first bill to this bill. And they took out some of that bad language, but they added in a task force now that's going to be looking at collective bargaining. With the idea that, again, we're trying to make sure. And qualified immunity. We're trying to make sure that the bad cops don't get their jobs back, but leaving it in the hands of still making sure that we have police officers or people who want to be police officers.
Can I make one quick connection?
Yeah, sure.
Yes.
So a lot of people talk about, well, licensing of police officers should happen. I want to be clear that certification is just really semantics for licensing. So we can be decertified, we can, be terminated currently. But, as people keep talking about, we need to add licensing in there. Really, that is the certification that exists in Illinois right now.
Correct.
All right. Man, the rabbit holes are just, right? I want to follow that one. Like, oh, no, sure. All right, let's get back to what we're talking about. We're segueing
into complaints
right.
against police officers.
Yes.
Okay.
So I gotta take a deep breath on that one.
So,
I don't get too emotional.
If you guys are just joining us, it's 8:42 a.m. You're listening to Good Morning Aurora, second largest city's first daily news podcast, and we are joined by Sheriff Ron Hain and State's Attorney Jamie Mosser, discussing police reform and HB3653. Okay.
So currently, and going forward for the future, modern law enforcement is incredibly well trained and incredibly transparent. At the Sheriff's Office, we are so proud of our new body camera program that we just launched and are still in the process of rollout, because it actually takes quite a bit of time to upfit and train everybody in the usage. So when it comes to making a complaint against an officer, you can go right to our website, you can fill out a form, you can call us 24/7 to initiate the process. We have a whole division called the Office of Professional Standards that investigates these complaints, and we have our union process where we bring these complaints against the officer after the investigation, and a disciplinary process, and progressive discipline.
Now, is this different? You are the Sheriff's Department. Is the procedure different in the police department?
No.
Okay.
So large departments like Aurora Police Department follow the exact same process.
Okay.
So under this bill, it basically, that unit still has to exist because we have to do the investigation, prepare reports, and forward said reports and all evidence to that independent review board.
Right.
Okay? So now we need to receive a qualified complaint. We need the complainant's name, we need the date and time of the incident, and we do ask for a signature, also known as a sworn affidavit of the complaining person. Potentially, if they make false allegations, we could charge them with the crime.
Right.
For lying.
Sure.
Okay? Under this bill, the complaints can be anonymous, no sworn affidavit is needed, and the complaint stays in the officer's file for their career, substantiated or not. Okay? Substantiated or not. Now follow me here. Let's say, and I have to use the estranged spouse example because that is one of the common complaints that we get. It is from somebody's ex-lover about one of our deputies or corrections officers. Now, that person doesn't have to give their name. They can call every week for 2 months and develop a pattern. Just make up any sort of complaint that they like about this officer. He pulled me over and yelled at me and said obscene language and used racial slurs.
Right.
And do this for a month straight. Now they've developed this pattern that can go to this the independent review board and potentially decertify this individual, because what else do they have to rely on? Oh, and look, none of those incidents were caught on your mandated body camera, officer, so apparently you didn't even have that on.
Right.
There's a class 3 felony. So not only is he decertified, but he's charged with a class 3 felony.
Right.
Yes.
There would still be a judge over this procedure looking at these bogus claims, correct?
So my understanding is that it would be on our office to investigate and provide all original reports from the anonymous complainant to that independent review board. Now, that independent review board, that's why I said it needs to have a whole lot of credibility wrapped around it, can decertify that officer, but that officer can't appeal. Now, he has to appeal it to that same review board. So.
And they can do an emergency decertification, so all of a sudden, this police officer is out of a job.
Yeah, look at these complaints that we received for 8 weeks straight. we have to do an emergency suspension.
One would hope that the police union would be backing that officer and going to bat for him, though, right?
It's been removed from the CBAs. That's
What's the CBA?
the collective bargaining agreement.
So that's what we were originally talking about, is that in the beginning, they were trying to take that away from the collective bargaining, so that unions then wouldn't have the ability to fight for the police officers.
Aha, okay.
So when you put all that together, that's why we're losing great police officers.
So a person is making these complaints. The process now is that they have to be a sworn affidavit under which, if you're lying, you are subject to the penalty of the law.
Perjury.
Perjury. So under this bill, if signed into law, a person can just make complaints without having to do that rigorous legal work beforehand. They can make their complaints, which stay forever.
It's not that rigorous, by the way.
Yeah.
To make a complaint, it's very, very easy.
Oh, right.
Protocol.
Paperwork increases. The ability to have your professional career dampened by senseless, charges increases. What in the world do you speculate was the reason for adding that and going away with the system as it is now?
So I'd like to jump in on this one. So yesterday I got a call from a friend, and it's a friend that I met during the campaign. And he was questioning why I was opposing that. Now, he has a criminal history. And in that criminal history, he has been found not guilty at trial, cases have been dismissed against him, and it's still being used against him. And I said, that's one of the reasons why we need to do this system better than what they're proposing. So he had the benefit of going through a court of law, and a judge found him not guilty of a case. But it's still on his criminal history, and people are still saying, you did this crime. But he was found not guilty of it. When you go through all of this and you have anonymous complaints, first of all, how do you investigate an anonymous complaint? I want to go back to Ron's example where somebody's calling me and saying this person is swearing at me and using racial slurs. Sorry, I could not get that out for the life of me.
You shouldn't.
Okay.
The time is now 8:48 a.m.
Sauciness. So there's not a way to do that. From my perspective, if there's an officer who's using bad language or racially charged language, I want that officer punished, but we can't investigate it now. So nothing really happens with it because there's no facts behind everything. So there's two things. One, somebody could be lying. The second thing is, how do we really investigate the bad when it happens? The other part of this is, when you make a complaint against somebody, you should be doing that under a sworn statement. It's the same way that every police officer who files a complaint against a person who's arrested has to swear to that, because if that police officer is lying, that police officer gets in trouble. We're creating two different standards. We can anonymously, and we can, without swearing to it, say a police officer did something wrong. Then you don't get in trouble when you're lying. But police officer, if you're lying, you do get in trouble. Why are we making two standards? If you are alleging a complaint against somebody, it should be the same way across the board, whether or not you wear a shield or you don't.
What's the cost as it stands now for a person to make a complaint and get an affidavit sworn and all that?
You say cost?
Yeah.
$0.
Yeah.
It doesn't cost anything.
Doesn't cost anything.
Not all. Then it shouldn't. But we need to have some baseline information, and we need to have a complainant to do a proper investigation. And the most damaging part, again, is the retention of the complaint, regardless of foundation, for the entire career of the officer.
As it stands now, how long do complaints against an officer remain?
Substantiated or not?
Unsubstantiated.
Unsubstantiated does not go in the file.
Substantiated.
Depends on the type of infraction. So it could stay in the file for a year, it could stay for the entire career. But again, in the most egregious violations, we move for severe discipline or termination, certainly.
Okay. Have there been cases in recent memory where a person made a complaint against an officer that was through the affidavit system as it stands now, that was entirely bogus and unfounded?
Oh, once a month.
Okay. All right. That's interesting.
And of course, the jilted lover complaint,
Right.
about once every other month.
Right.
So again, one of the ways to change this language, because that's really what we're talking about.
So you don't want this removed from the language should change.
Yes.
Yes, because one of the concerns is people are afraid to file a legitimate complaint against the police officer because they're afraid of retaliation, because that has happened with bad cops.
Mhm.
So there's a way to put in language that protects the identity of that person so that the investigation is able to go through to substantiate or to unsubstantiate something. So again, there's ways to do this in the right way so that, again, we can investigate the bad cops without hurting the good cops.
Yeah, we can certainly meet in the middle on this one. I mean, get rid of the sworn part, get rid of the signature line. Okay, I'll meet you in the middle there. But again, we need some information and we need the ability to remove that unsubstantiated complaint from an officer's file.
Because there has to be a reason behind it. In criminal law, if I call a witness to a stand, there's certain things about their credibility that can come in. If you have a prior felony conviction or if you have a conviction for lying, you know, there are reasons why we can bring in information, but there's limits within the law. For a crime itself, we can't get in anything that's older than 10 years. So why then do we have something that stays in a police officer's file forever if the law doesn't even consider anything that's older than 10 years?
You know, I listen to this and I think about the procedure, and I think about law enforcement, and I think to myself, it doesn't sound outlandish to have 5 years, 10 years, substantiated claims or actions on an officer's record that if he does something else egregious, the court could look at for prosecution.
It's called progressive discipline.
I do think it's outlandish that unsubstantiated claims from anonymous folks would remain on an officer's. But yeah, I just don't see how that would stop me from being a law enforcement officer if I wanted to be one.
This is an incredibly noble profession that requires a great deal of courage and discipline to maintain even into a 5-year career.
That's why I bring it up. That's why I bring it up.
15-year career. When you look at officers who serve for 10, look, I'm going to speak personally. I've done this for 23 years now. I sincerely love the job, love the profession, love who I stand for throughout Kane County. But internally and for my family, I am looking down at the light at the end of the tunnel that says I can retire with a pension well, I can retire now, but I won't be able to draw until I'm 50. In 5 years, when I turn 50 years old, I'll be able to retire and enjoy my life after all the investment that I've put in to this job. It is daunting when you're a 5, 10, 15-year police officer to go at any point, I can become decertified, I could be charged with a Class 3 felony, I could lose everything that I go out every day, put on this uniform and work for, lose all of my pension, lose all of my credibility and integrity just because of an anonymous, unfounded complaint.
Yeah, you're looking at your career and saying you'll never make it to 20 years. Sure.
So why do it? Why risk my life every day?
Put that in the context of what we, and I'm talking about all of society, have done to create the situation that we're in. The lawmakers created this war on drugs. I want you to think about when all of this was passed a long time ago, when the drugs were starting here, cocaine, and the difference between powder cocaine and crack cocaine, and we created these laws. We made this unworkable environment, and we told police officers, go out and arrest people. And that's exactly what they did. We had great police officers that did exactly what they were supposed to do, and then we had bad police officers. But we gave them the laws. And then we started to take money away from social services. We weren't giving money to put people into treatment. We took away mental health services. Our mental health services here in Illinois, for the most part, are a joke because we don't have what we should have for people. But we tell police officers, you continue to do your job. You continue to arrest people because these are crimes. Then we changed some of the laws. We figured out that, yes, we were absolutely racially profiling people of color because they were using crack as in the rocks versus powder cocaine.
Right.
So we changed that, great, but you know what we kept doing? We kept taking money away from social services, and we kept saying, you know what, police officers, you deal with this problem. And then here's where we are, because we took money away from where we should have put money, and we put all the burden on police officers.
Two bipartisan issues created the issue where we stand today over the 80s and 90s. One was the war on drugs by Ronald Reagan, and you saw the prison rates escalate through the roof. I think it was 400% increase in prison rates between 85 and 1990. The second thing that created it was Bill Clinton's cops grant. Do you remember that from the 90s? That's what hired me.
I was like 9, but
The whole idea was, okay, we got this war on drugs. Look at all these arrest rates going up. We got so much crime going on. Look at this gang crime activity, guns, shootings, etc. Let's flood the streets with cops. Let's put all these boots on the ground. And when I went to the academy in the 90s, it was all about aggressiveness, putting away those bad guys, go get them attitude. When I came out and I was a young deputy at my different sheriff's office, that was the whole theme of the administration I worked under, is go get those bad guys. And then I finally stopped one day and I turned around and looked, and I went, wait a second, all the bad guys are in the low income areas. And who lives in low income areas but 60% black, 30% Hispanic, and a very small percent white? Less than 10% white lives in low income. That's a national statistic. So we've been training cops for decades plus to go get those bad guys who are the minority community, and have created now what we see, well heck, since 2000 really, all the way to 2020, this antagonistic relationship between the police and minority communities. But who really created the environment that we're in? The government. And I love her point. Get back to funding social services, get back to drafting the right kind of legislation, and refocus law enforcement administration to approach the community in a different fashion.
And let's be clear, that's not defund the police.
No, of course not. Yeah, right.
Because that's this whole movement right now. And when you really ask somebody, what does defund the police mean? What we're looking to do is actually start to work together as a community again. Create laws that put money where it should be. We need police officers because you know what? Social workers, counselors, they don't want to respond to these dangerous situations. You know what police officers don't want to respond to? Situations where a person is having a mental health episode or something that's happening because they've taken too many drugs or bad drugs. We created this system, and now we're creating laws that are trying to undo some of that, but not in the right way because we're not working together again. I want to work with the sheriff. I want to work with the community. So let's do that and create those laws.
Y'all want to work with more in Aurora?
We always want to work with you first. We just get to come up.
I know. All right, so here's the thing. Just for a quick pause, which of the two at the moment is worse? The ending of cash bail or the complaint system against officers?
The complaint, well, so ending cash bail is great. The way in which they've written it is bad.
Sure.
The way in which they have written this ability to complain against police officers is bad.
There's no good in that, it appears. You guys, there's no...
There's a way to write it that makes it good.
Okay. Yeah. Now, I do want to say that you're a lawyer.
Yes.
So you're fluent in legalese.
Yes.
A lot of people are not, you know. So they hear you and your ability to describe the nuances and language of what it would mean as applicable by law, and they don't get that. I think one of the things that the community has a problem with is that they look and they see the ending of chokeholds, they see more access to mental health, they see the ability for people to get a couple more calls in jail or whatever. They see that, and then they hear you guys, or not you guys, they hear it's anti-cop. And they think, how can good things be anti-cop?
And that's why we've been screaming from the rooftops. There are so many good things in this bill. And the altruistic fashion, the word of the day, of what this bill is trying to accomplish are all great.
Right.
However, there are so many components that are missing, that are, I'll use your phrase early on in the show, not well thought out. But we really are just desperate to shout from the rooftops, to get at the table, to help everyone iron this out and work together.
I defer to law enforcement when it comes to law enforcement issues. I've never worn the badge before. I don't know what it's like to do that job. I believe that if you're going to get facts, you're going to talk about police reform and law enforcement, you should be talking with them. Do the folks who wrote this bill, what was the process like working with them, or did it exist at all?
So obviously I just took office, so I didn't get to
Right.
have.
This has been a long time to make it.
Correct, and so, I want to meet them, so, I think it's Senator Sims and Representative Slaughter, and I could be mistaking this senator and representative. So I do think that they had a great idea with this, and this is my problem with it, it's 764 pages. That
Aren't all bills
chokehold,
760?
yes, but why? How about let's have House Bill 1 that removes chokeholds? Great, you're gonna hear us saying that's fantastic. How about we have House Bill 2 that deals with pretrial release? How about we have House Bill 3 that deals with this? That's the problem. We have two sides arguing things because they're trying to create the problem. We have this is anti-cop who's not looking at the reform. Then we have this is pro-reform who's not looking at the danger to the community, because it's so easy to say this tagline. What we're trying to do, and it seems like we're trying to get into the weeds of this, but it's only because we see it on a day-to-day basis.
I think this is important enough to get into the weeds on. It seems, yeah.
Exactly it, but
Can you
that's
jam all those separate bills through in less than a week in a lame duck session now?
right.
Apparently you can, right?
Yes. So that's the problem. Both sides are right. Both
Yeah.
sides are right.
Great way to say it.
So let's just get to the table and now get it right.
Okay.
Because again, what they did was they put it out there. Now we have criminal justice reform, and congratulations to both of them. Like, I'm excited about this. Ron's excited about this. We're ready for it.
Right.
But you gotta fix that really bad language that we've talked about.
And we're not saying, I want to be really clear too, that we're not saying that they're not listening to us now. We just had a call with two great new state representatives yesterday. I've been in conversations with one of our senators and another state rep that has a forthcoming conversation with us. So now they are talking, and our law enforcement and states attorney associations have been part of discussions like the broad overview of criminal justice reform earlier in 2020. However, when it came down to the real preparation of this bill and the nuts and the bolts, both associations were pounding at the door saying, let us in, come on, we need to make sure this gets right before it gets on the House floor and the Senate floor, and they were locked out of the room.
All right, here's a couple of we're gonna do the quick session series, right? Remember, like,
Yes.
as you, what show was that? Did I miss that? Anyway. Does this bill make it easier for criminals to get away with crime?
No, to get away with crime, no.
Okay. How silly that question was?
Yeah.
I'm right?
So
Criminals get away with crime.
So I will say this, they removed a law, I shouldn't say removed it. So the law of resisting or obstructing a police officer now has to have a predicating offense.
That's where I was, okay, right.
So I'll give you this example. An officer makes a traffic stop, and this happens quite a bit here in Aurora when it comes to gang crime activity. Officer makes a traffic stop, the driver will stay in the car, everybody else jumps off and takes off running.
Right.
Probably 2 of the 3 of them have guns on them.
Yeah.
Okay? But the officer doesn't know that at the time. Why is he chasing those people? Well, that's resisting and obstructing a peace officer, because during a traffic stop, a peace officer is the only one that can order you in or out of a car. So these people immediately in that position are, again, resisting that officer.
Sure.
He technically can't chase them because he doesn't have a crime to chase them for.
So what that means is that, so you're pulling over a guy. You can't do that unless you have a reason to ascertain what he was going to do. Is that?
You can make the traffic stop, certainly,
Okay.
for an Illinois vehicle code violation.
Right.
But many times, because we have proactive police officers in Aurora and proactive deputies that work in the community,
When the
they're
guy's
out
running out, you
doing-
can't chase them.
Technically not, because
Okay.
you were stopping that car for a traffic infraction.
Now here's what.
You don't have a predicating offense to that resisting. You just see people taking off and running.
Now, Sheriff, this is for all of you people out there. The time is now 9:05. Sheriff, are you telling me that a car known gang members or a gang member owned car, this vehicle has been reported many times, our officers have pulled this guy over, we know who this is. Are you telling me that he gets pulled over, shots fired in the area, dark gray Honda, we got the dark gray Honda, pull over, the guys get out. Are you telling me, Sheriff, that when this bill is passed, they will not be chasing these guys?
What it does is it actually is counterintuitive to the bill, because you're going to have officers who are altruistically doing their job, and they're going to have to add crimes to justify a crime, if you follow.
According to the bill.
According
to the bill, okay.
Because again,
All right.
simply, I love that scenario you just portrayed. Again, if they jumped out and started running, okay, you have the crime of resisting a peace officer, give chase. And hopefully you catch that guy, and maybe he's got the gun on him, and you just solved a shooting, right? But under that scenario you just laid out, under this new law, no, you have to wave goodbye.
Okay, so let's say you know what? Forget that. I'm not waving goodbye. I joined this department for a reason, and I'm going to chase this member of the whatever. I chase him. He's got the gun. What happens now since I violated that? Am I getting locked up for that as an officer? Is the judge going to ask me, why did you chase this guy? You didn't know that how'd you know he was a gang member, right? Is that what happens next?
Courts do not allow for bootstrapping. So basically you can't say, well, I gave chase and then I did find a gun, everything's okay, right? No, you have to have that predicating offense before you can arrest somebody for a crime.
If this bill is signed.
If this bill is signed.
Again, it's one of those things where we understand. If you think about it this way, you're arrested for resisting a peace officer, but there's no other charge. From a layman's perspective, yeah, that I don't understand it either from that. There's a way to write this law that does what it's intended to do, which is not just to arrest a bunch of people of color. Because we have seen that happen. There's no question about it. His jail is filled with people of color when that doesn't match our population. Our population does not have, what do you have in your jail?
So, you're gonna let me go off on that.
There's more black people in the jail than in Sugar Grove or St. Charles.
The black population in Kane County, whole Kane County is 6%.
Right.
Our average black population inside the jail is 37%, as high as 46% in my 2 years. Oh, I'm sorry, I'll let you.
No, you're right. But what I love about this article is it puts all kinds of training in there, but racial sensitivity training, training towards mental health, training towards de-escalation, CIT training. You're just distracted.
What's CIT?
Critical incident training.
Crisis intervention.
Crisis intervention training. Damn it.
I'm bad with the
This is what I need to let you answer sometimes.
That's fine. That's why I took that budget over, by the way, the
Yes,
CIT budget.
I know, which I'm okay with.
Okay, so we've got an increase in training, but we're allowing, we've got an increase in training, but we are allowing, we're not having officers give chase in that scenario. We've got an increase in training, but we are allowing anonymous complaints against officers. We've got an increase in training, but we're taking away cash bail. Besides those, from a law enforcement perspective, what could be worse in this bill? What else is there?
I got a good one. So, when you're arrested and you go to bond court, very next day, because you have to go to bond court within 48 hours. It's usually the very next day.
Sometimes, if you get arrested on a Friday, though, you ain't going till Monday.
Oh no, you're going Saturday.
Oh, they got a weekend judge?
Oh yes, absolutely. We have.
I didn't know that. That's just what I heard from you people in the comments.
We do. We have it every day. We have it on Christmas.
And 2 times a day.
Yeah, 2 times a day. We have it in the morning and we have it in the afternoon. So you're going to bond court pretty quickly. So the way the law is written now, you defendant have the right to bring witnesses as to why you should be released. Not that the crime didn't happen, but you have a place to go. You're not in danger. We're going to get you to treatment. We're going to do whatever. You have that right. Fantastic. That's exactly what you should have.
Correct.
They have changed the law to say that if the defendant says that by clear and convincing evidence that he or she would be materially prejudiced if the complaining witness, that's the victim of the crime, if the complaining witness has to come to bond court. So I want you to think about this. Victim sexually assaulted, goes to the hospital, a rape kit is done that evening, police are called, police do an investigation, police identify suspect, arrest suspect, charge that person with the felony offense of rape. That person is brought to bond call the very next day. That person says, I have to have the victim here because it would materially prejudice me as to whether or not I can be released if that victim isn't there. The judge can then compel, that it means mandate, that victim has to come to bond court. 1 day, 2 days after the incident happened.
And that type of arrest and crime is more common than most people realize.
Correct.
And seen in our bond calls.
What benefit would the perp have the victim is obviously not going to speak good of this person. What is the...
I don't know. So again, let's say the victim wanted to come to bond court and say whatever the victim wanted to say. Fine. Why are we compelling a victim of a crime to come to court 1 or 2 days after the incident happens?
We're trying to think objectively about this, Curtis, just like you're doing right now. I can see it in your eyes.
Like, why is it so quiet?
What
Speechless,
is
that's what I
the
did to
benefit?
him.
And
Right.
I can't find
Right,
a
because
benefit to this.
it's not whether or not the crime occurred, it's whether or not the person should be released.
A judge can still hear all that and say that this perp is not being let out of jail.
Correct.
The judge, this is something that this is, for my layman's terms, I've wanted to understand this with the whole bill. A judge is still able, even if it was signed into law, a judge can look at this and say, I'm supposed to let this, nah.
Right, a judge can say no.
A judge can say no to all of this, even if the bill is signed.
Well, you mean for the victim part or holding somebody? So
Holding.
no, because if
Okay.
a judge cannot hold somebody if the law doesn't allow the judge to do so.
Okay, all right.
And that's the bottom line, is that what this is doing is tying the judge's hands in some circumstances. And the reason why is because unfortunately we have people who are held pre-trial in cases that when you really look at it, maybe they shouldn't have been held pre-trial, or maybe they were held just because they didn't have the $50 to bond out.
Right.
So again, it's really trying to eliminate a long-term problem that we've had
It's just doing it
in a
in
way
the
that
long
could
run.
have really bad unintended consequences. So again, great idea. I think we're consistent in that message. Great idea for criminal justice reform, but let's have the language changed to make it do what it's intended to do.
So,
We're starting to sound like a broken record.
We are.
well, that's what it takes,
Yeah.
though, right? That's
Yeah.
what it takes, because people are sounding like broken records. I was listening to broken records, and you just answered the record for me.
So,
People were saying things that I just heard from you was not the case. So
Right.
this is good.
and Curtis, this is what happened because I jumped on Senator Villa and Representative Hernandez put out a Facebook Live event, and that's where you saw me posting. And first of all, I did it in a very unprofessional way. And I've apologized to Senator Villa and
There
Representative
was like
Hernandez.
740 comments.
Oh my
I don't
gosh.
even know. They were just, it was like hotcakes that day.
And then there's me too, and I'm doing it, and I've apologized to them, and I owe it to the representative and the senator too, because I need to do it a better way. But this is one prime example of how not political I am, and how passionate I am about all this
I
stuff.
get you.
Yep.
And you know what, Senator Villa and Representative Hernandez are listening to me, and they are listening to the community. But they're also doing it in the backlash of the people who are on opposite extremes, who are saying no or yes. And we need to, again, be right in the middle, talking it all through.
All right. I want to talk about the defunding police
Mhm.
specifically part. Now, if I'm not mistaken, there was a part in the bill that said that departments that did not comply, non-compliance would mean a lack of funds, or taking away of funds, or the limiting of funds. That was about as defundy the policey as you could get with that specific language. But that language was taken out. Correct?
So that still exists in there, but it really applies to grant funding from the state.
Ah,
So hardly any of my budget, I'm trying to think of anything specifically that is funded directly by the state that we depend on a daily basis. One grant that we use for correctional purposes is, if that went away, I'd lose about $110,000 a year out of a $32 million budget. So,
Okay.
I mean, it's not breaking the bank. I understand the purpose of it. And we're, by and large, going to comply, and we already are in compliance with the vast majority of what this bill states. So, I mean, it's not a tough road for us to haul. But when it comes down to body cameras, and I speak more so on the behalf of sheriffs, south of I-80 and western 39, but they don't have the budgets that law enforcement does here, or the resources in northeastern Illinois. And they're really scratching their heads, and their county boards are scratching their heads, and their municipality boards are scratching their heads going, how are we gonna come up with a body camera program that we can't pay for? So I've been trying to point to funding shares that the state should provide. I think the new cannabis tax, a certain portion of the cannabis tax is allotted directly to law enforcement. We're receiving that now. But Kane County is a fairly large county. We do have dispensaries. We are gathering the tax. The sheriff's office has only gotten $25,000 from 2020 cannabis tax. Now you go downstate and you're going to see a much less income, and our body camera lease contract is $170,000 a year. So agencies are going to have to come up with money from the state to be able to make this happen.
Including
It does become
prosecutors,
law.
by the way, because all of that body cam footage comes to us. And when a case is charged.
That's not
and-
my concern.
And we have to store it, and we have to review it. And now we're gonna review a lot more. We're already overburdened, our prosecutors. We already have more cases and more work that we have to do, and this is gonna create more. So there's more funding. And I do wanna segue into one other thing about body cams, because this is something I can't believe you didn't mention. Part of what it says in here is that a police officer who goes to a scene and something happens, an arrest is made, is not allowed to review his or her body camera footage before writing the police report.
I thought we were going to segue into body cameras.
What?
Right, so this is what I wanna give an example.
Okay.
I often, in my jury trials, especially my domestic violence ones, have to explain why a victim of a crime has a different story from the scene to the time of trial. And I want you to think just the trauma on the brain when something bad happens. Because that's what our brain does. Our brain protects us. Fight or flight or freeze, and there's a whole new one that's
Right.
in there. And so as a result of all of that, when you first are asking for help in a 911 call, a victim is gonna be very limited because it's just, I need help. When an initial police officer comes, the victim gives a little bit more, but is still under the stress.
Sure.
The detective eventually follows up. There's more information, but you're healing from everything. 2 years later, when this thing goes to trial, you're in a better position to be able to describe stuff. And defense attorneys everywhere are saying, well, these are all different statements. And I say these are not different statements. This is what happens. This is real life. Police officers aren't exempt from that. When they're coming up on a shooting, this is
Wait,
traumatic.
police officers are human beings?
Yes, they
Oh,
are.
because this
Sheriff,
bill,
don't do that. You know on this show we don't. Come
this
on.
bill dehumanizes police officers.
A
As a-
It dehumanizes police
A
officers.
portion of this bill
Yes.
dehumanizes.
Thank you.
You're
For
welcome.
clarifying, a portion of this bill as it sits
Yes.
dehumanizes police officers.
Because it
I'll
doesn't
let her
take into the
finish.
fact
Yeah,
that
yeah.
that's stressful. I mean, I've never been to a shooting, but you know what? I would be scared to death. Police officers have to go in there, and despite all of their training, they're still going through all of that. The adrenaline is running. So if a police officer wants to accurately put down in a police report what happened by using the body cam footage after they're calm and they're able to look at it, why would we prevent them from doing so?
Okay.
So they can perjure themselves?
Okay, here's the thing. There appears to be no punishment, has not been, for officers who delete or destroy body cam footage. Is it possible that that part, maybe, you know, they tried their very best, could that possibly be the reason behind that?
There is punishment for it. Look at what happened with Jason Van Dyke and those other police officers. They lied in their reports, and the only reason why they got caught with that, obviously, is when the footage came out.
Chicago Police Department
Yes,
officers, right?
right. So they got charged with those offenses, and it is Joe McMahon, the former Kane County State's Attorney, who went down to Cook County and held Jason Van Dyke accountable. So that's important
that's
to
true.
know. But the difference is, they should have looked at their footage, they should have been truthful, but they lied. They lied, no question about it. What this bill is doing is preventing the good officers who do want to accurately report what happened from being able to utilize a tool to do so.
And Curtis, you are right. That's what the intent of the bill is.
Correct.
To make sure that it gives, by law, police administration and supervisors the authority to lock down that video, control that video. It
Right.
doesn't give the officer access to it, but it stops there. It doesn't clearly state that the officer can review that video. What it states is only the supervisor can review it. The officer can't review it until after he writes his report.
I'm gonna try, you know, I think in the minds of the people who crafted it, they probably thought, you know what we're gonna do? If an officer's good and he's got nothing to hide, he shouldn't have to, right? If you responded to the call and the suspect was violent and you restrained him and all this, and then you shouldn't have to want to go back.
But Curtis, if somebody ran in here right now and punched all of us, we're gonna have 3 different versions of what happened, not because we're lying, but because we have 3 different perspectives of it,
Sure.
and something stressful just happened.
True.
So again, what we wanna do is punish people who lie in
Right.
police reports.
Right.
But if you have a perspective of what happened, it doesn't mean that you're lying, it's because of what happened, it's because what the brain does. It's the same argument that I have for victims who are in a traumatic event. Why not let a police officer accurately depict what happened by
Sure.
looking at the report? Because again, all he or she is trying to do is write it down accurately. What you're gonna see if this goes through is that police officers are gonna write a police report that says see body cam.
Yeah.
That's all
What's
they're
wrong
gonna
with
do.
that?
Because it puts more work on everybody else, because we can't look at it, we, the prosecutors, now have to watch hours and hours and hours of it before we're even able to prep anything, because we don't have a police report that's used to summarize that we use to do our job in the very beginning.
And I
That's how
asked,
my
right,
deputies-
right.
Yeah.
I did tell my deputies if this becomes law, that's the way we're going, and they were actually pretty excited about that.
See body cam?
Yeah.
Yeah, no, I didn't say that to be joking.
Yeah.
You know, I'm trying to mirror what the sheriff said when he spoke about law enforcement when he started. He said the noble profession of law enforcement. And that's one of the problems that I've had with criticism of the bill and its anti-copness. I don't believe anybody who really loves their job would be dissuaded by, see my damn body cam, I don't got nothing to, you know what I mean? That's how I'm looking at it. But I do know that law, sure,
Right.
law and how it's written does take precedence when you're a professional law enforcement. I do believe with this body camera issue, personally, as a citizen, that, well, wait a minute, if signed into law, departments have until 2025 to have body cameras.
Yes.
It does graduate by population,
Yes, so,
Okay, all right.
and I don't know the exact steps.
I believe that all officers statewide having body cameras would do a lot of good. I really do believe that.
we are in agreement with
I really
that.
do believe
It
that.
protects both sides.
If the language said that officers are entitled to look at and review footage, would you agree with that?
Yes.
Okay. See that we're getting along on the show. Oh, snap.
When we were talking to the state reps, I think it was yesterday, they did clarify that what it meant to state was,
Right.
they can view it, it just has to be under the control and authority of a supervisor.
Correct.
Okay.
Fine.
Spell that out, please.
Yeah, exactly.
Right.
Again, we're fine with this. There are those things again. So I wanna, you mentioned this phone call issue, how they're putting in 3 phone calls in 3 hours. So you're at the police department, 3 phone calls in 3 hours, you're at the jail, or then you go to the jail, 3 phone calls in 3 hours. This is all coming from an issue that occurred in Chicago, where 2% of the people who are arrested actually got phone calls. That's a problem. There's no question about it. Our law says that you're supposed to have reasonable access to a telephone to talk to your family or an attorney.
This is
Again.
great.
Yeah, nobody has an issue with this. It just seems to become an arbitrary thing because what they're trying to deal with is an issue in Chicago. Can I tell you that this one and I have fought recently because of the sheer amount of phone calls his inmates get.
Hold on. I see.
Yes.
I think this is a good place to plant the flag. I do believe though that yourself, Sheriff Hain, and yourself, Jamie Moster, I do believe that, and for those listening who live in the county, I do believe that a lot of the opposition to this bill is extrapolated to the goodness that happens and has happened within the Kane County system.
Yes.
There are right now somebody's getting arrested in Itasca or something like that. And the arresting officer is like, we'll get to your phone when you, don't worry about all that. Somewhere right now somebody's got a phone and not able to get it for whatever little, when the shift changes, they'll come and give you the phone.
Right.
That's why I agree with the statewide policy of that, because the little places where it does happen is one incident too many. Is there a way to maintain professionalism and within the jail system and be able to accommodate individuals with the phone regs?
Yes, absolutely.
Okay.
Again, it's cleaning up the language. One of the things that I have within this is it says that they're allowed access to their phone.
Right.
Now, I don't know if you have all of your family and friends' phone numbers memorized. I know my husband, that's pretty much it.
Right.
So, with that being said, I would need to get in my phone to look at anything. What happens if that phone has evidence on it?
What do you mean?
So, let's say it's a telephone harassment crime.
Oh,
Correct.
right. Your phone is remanded into custody. That's part of
Correct.
evidence.
So, and let's say an officer denies you from having access to your phone because it's a part of evidence. Is that an issue? It's not spelled out in this. What happens if we give you access to that phone and you hold it and you delete all the evidence out of it? Now, could we undo that? Sure, there's technology for it, but it's making it more difficult. What happens if Sheriff Hain says, give me your password, I'll get that phone number out for you? And then he does that, and then there's constitutional arguments about the fact that now he went into the phone and you shouldn't have any evidence. The problem again is the language.
I got you.
I do want everybody to have a phone call, and frankly, if we have the definition reasonable in there and people are violating it because they think reasonable is 2 days later, put a time limit in there.
I got you.
I'm 100% just fix the language.
I got you. That makes sense. That makes sense. I don't believe that the process of intake for inmates should be hard on deputies. I don't believe that. So you know, let me just say that. I don't think that, you know, look, I don't think that guys should be getting steak and lobster and your feet up in your house shoes during the intake process. I don't believe that. I do believe though that the laws need to be updated per the time.
Yes.
The process still seems to be of the old days with rotary phones when people were remembering numbers, and now we don't have to plug in the phone before it dies and get my mom's number out of here.
Right.
So I think that needs to be updated accordingly.
Agreed.
Accordingly. But yeah, I'm not for burdening the deputies with undue stuff
Well,
when
and
a
I don't
person
think
gets
it
left.
does. If a person has to have a phone call with a certain time limit because people have incorrectly denied people, unconstitutionally denied people, let's just fix the language again so that it does what it's intended to do, and it makes sure that the rights of defendants are protected just as much as the criminal justice system continues on the way it should.
Was law enforcement better before this bill?
We were heading in the right direction. Again, broken record, we love this. It lays out many things that need to happen. However, still has a very long way to go. Law enforcement regionally, as I always say, is incredible in my opinion. We have, like I said before, very well trained officers, incredible police chiefs throughout Kane County. We are spoiled in this region to have the law enforcement that we do. But again, putting it into law, I support. This is a long way from done.
Do you support a statewide standard for officers?
Certainly.
Okay.
We have those.
Okay.
Yeah. And there are many restrictions already on the books and other laws that are, I don't know how you want to say it, but re-massaged in this law.
I don't know that I like that language, but
If this bill gets better, I'll change it from re-massaged to adjusted.
Chiropractic.
But right now, it's
that
massaged.
alone is enough to change it, so he stops re-massaging things.
Yes.
Right. All right. So a couple more things about the bill that have been problematic to folks. Let's talk about how this bill will impact domestic violence cases specifically.
Okay.
Is this bill, if signed into law, a threat to domestic violence enforcement?
No, again, it puts some more language in there, so go ahead. I'm sorry.
There's people who believe that, though. There's people who believe that
Right.
if Pritzker signs this, fathers, that's it.
No, and so part of that is this whole concept of electronic monitoring. So when we talk about electronic monitoring, we understand that that means two things. One, you're on a bracelet in your home and you're not allowed to leave your home. Or two, you're out in the community, but it's a GPS device, so we know we see your little dot going all over the place, and you can't go into this protected area.
Right.
So one of the things, when you're allowed to cut off your bracelet and it doesn't matter for 48 hours, that's a big thing.
Right.
The other thing is it put in language that said that electronic monitoring doesn't necessarily need to be electronic, which means we're putting you on electronic monitoring, but there's no bracelet. Please stay home and please don't go to the victim.
They got the phone system thing though.
But
Right.
what phone system thing? As in I can call you and you're on your cell phone anywhere?
Oh.
So that's the problem again. Yes, it lessens our ability to really monitor domestic abusers. And if you look at what's just happened in December and January here in Kane County, we've had a lot of domestic issues, murders.
Right.
Our domestic violence cases statistically are up, and I think we're up like 5%, whereas we're down everywhere else.
Ah.
I want you to understand that.
We're up 20% compared to 2019.
Right, so that means it's just, our domestic violence is booming. Our abuse and neglect cases, our kids who are being abused and neglected doubled from the year before to 2020.
COVID had an impact on crimes, specifically in the home and domestic, going up, correct? Because folks were not.
Correct.
Yeah.
They couldn't
It's
leave.
really, really interesting stats. We are up in that category 20%. However, across the board in crime, we're only up 1%, 2019 to 2020.
Right.
And it's just a broad disparity where normal calls for service are way down. The type of stuff we used to go to before isn't happening, like traffic crashes are way down. By the way, the reason why, if people watching and people hear me stuttering, the reason why that is and fidgeting, because it's 40 degrees in here. So, I just want to be clear.
And I
Like, man, the sheriff nervous, man. Like, now he's
2020 is just a.
I tried to turn it up.
It's
I
got
don't
a
have any
huge-
coffee either, so there's a problem.
Well, man, you guys are performing well, but no, I'm over here nervous.
I'm heavily caffeine, but yeah, no, 2020 has such a huge, very bond-sized asterisk next to it when it comes to crime and what we're seeing out there. And domestic batterers, like, great answer with and this is your wheelhouse, and that's why I prefer that you talk on domestics, but also the compelling of a victim to come to court. Think about that domestic situation.
Right.
So yeah, this is gonna, to me, it's gonna have a dramatic impact on people even calling about a domestic. Victims report.
Want to read a comment. Glad to hear that Ms. Monster and Sheriff Hain agree with the intent of this bill. I understand the frustration of not being at the table in the creation of the legislation. Surely there is some language that can be improved, but the intent should not change, even if the police don't agree with all of it, like external licensing. Do you agree with that statement?
Yeah, I think I agree with the entirety of the statement. I don't think law enforcement as a whole disagrees with the bill. The huge part that I do disagree with is the disciplinary procedure.
I think the problem is that when you put all of this in 764 pages and you ask us to say we like it or we don't like it, the answer is we don't like it because of the language and the bad stuff that's in there. That's the problem with this. If you piecemeal this out, we could say like, don't like, and we're gonna like the majority of it. The intent should never change. The intent of criminal justice reform should not change.
How has this bill impacted your job specifically?
Well, I've had to read it several times, and instead of being able to focus on what I'm trying to do day to day, I've had to go to a lot of meetings. I've had to read the many versions of it. I've reached out to people. I clearly spent my Sunday night commenting on Facebook, and I never comment on Facebook. So it's changed it a lot because we're putting so much focus into making sure that we're heard on this issue, that we're not doing our jobs in the best way that we possibly can.
What about for you?
Yeah, there have been so many distractions over the last 2 years as sheriff that, yeah, we moved the ball a long way. We got a lot of things done. But, you know, between COVID and the civil unrest that begat what we see here, the massive distractions are taking away from the good that we should be focusing on to truly move the system forward and truly drive the reform that we've been doing. And now that Jamie's on the team, whew, so excited, because we're going to make it happen. But yes, just over the last week, I would say 60% of my focus has been on this. And I am like Jamie, I'm a bad politician, I'm a bull in the china shop. And when I get emotional on things, especially when you're talking about attacking the livelihood and careers of, again, the incredible profession that we have north and south along the Fox River here in Kane that we're so lucky to have, I'm going to get mad.
See, that's why I like talking to you guys. I really do. You can go back to the interviews that we had. Like, that right there, that's my only kind of stickler with the bill. Not having sheriff in law enforcement. Like, the statements of abject hatred and anti-gun.
Thank you.
I think that's just, I think it's a little much, you know? I think it's a little much. you know, I've had police officers in my family. I personally don't see it as anti-cop, but I really, really enjoy hearing what law enforcement professionals actually feel about it.
Yeah.
Why do so many people, you know, it's got to be more to it than just a complaint, right?
Mm-hmm.
Is it really attacking the heart of the police officer? I would think that there's more worse things that could be included in a bill to truly be anti-cop.
This completely shakes the foundation of every single officer's career.
Even though qualified immunity and collective bargaining are not in it?
Yes. The way it is written regarding your complaint system completely rocks every police officer's foundation.
Talking about other, hey, you know, hey, well, keeping it light this morning, right? All right, so I want to read something. Give me a second here.
Read some of the nasty comments. There's got to be something.
Oh, well.
Why you?
That's always entertaining.
No, it is actually, because it's indicative though, and it highlights what people feel or want to feel or want to think. Here's one. There's a person who's I think mad at me. How can you not believe people wouldn't want to be cops as a result of this bill? You keep mentioning this. Even the person with the best intentions will not want to work in a situation where anyone can make an unsubstantiated complaint that would get them fired or would haunt them for their entire career and possibly limit advancement.
Yeah,
Even in private sector, an employer will look into a complaint unless they were looking for a reason to fire you. Think about it. If one had to choose being a cop under this bill or going into private security might look more appealing.
So Curtis, I mean, you've had bosses before.
Mm-hmm.
You've had jobs that you like.
Mm-hmm.
You ever had a job where you didn't like your boss? You had that sick feeling in your stomach every day you went to work because you had to look over your shoulder like you felt you were going to get in trouble for anything you did? You ever had that
Yes,
feeling before?
I have.
Yeah, and if you have a heart, and which I know you do, and you want to excel at your profession, and you want to provide for your family, and you want to have a solid foundation, and you remember to turn your body camera on every time you should turn your body camera on, you should be able to go to work with pride and comfort in your profession.
That's true. I've also applied for jobs, got the job, been in orientation, and then pulled out of the orientation and told, hey, you know, your background check has some 1997 shit, which was dismissed, and you know, we gotta let you go. So that embarrassment and that knock to my attempted professional growth is problematic.
Indeed.
And as much as I understand how bad it would be for records to follow peace officers, I contrast that to a person who is sincerely trying to change their life and not being part of recidivism, still having to answer for a 1997 or whatever the other thing. You know what I mean? So I see where law enforcement's coming from with that. I see that from experience, and that weighs more on me than a boss that I don't like, and you know, I know this guy's looking for a reason to fire me, so now here it comes, you know, JJ, who I arrested for a gun 2 years ago, is now calling, I know it's his voice, you know, calling, oh, Sheriff Hain beat me up at Don Walker's, you know what I'm saying? I feel you, I feel you. That's where I'm coming from with it, and that's why I like talking to you guys about it, because you know, I'm able to see both sides of the spectrum. I totally do. I don't think any officer should go to work every single day under the threat of some idiot calling in and making a complaint, you know, from the luxury of their home. Keyboard warriors. You and I have talked about this before.
Oh yeah.
I don't think I don't think any keyboard warrior should be able to get a good deputy fired.
And Curtis, that's why I like coming here and talking to you, so feel free to have me on more than once.
Oh,
Like,
please.
Yeah.
You know, some of us seek Curtis out. I believe I invited you after I asked Curtis.
Oh, that's right. Wasn't even on his radar.
No, you are on my radar because I do. I've been keeping up with the activities of the Kane County Sheriff's Department. I follow you guys on Facebook all the time, and I see what you guys are doing. So I'm, always impressed with what you guys got going on.
So Curtis, did you know in here, because some of what they did is there's rules in here that if you're a police officer and you commit a crime, that could result in the decertification.
Yes,
okay?
yes.
Did you know that it's in here that when a person is applying to be a police officer, if you have something in your criminal background, you can't be a cop?
Yes.
So I want you to think about you're 18, you just turned 18, and you did something stupid, and you committed a crime. And that's on your record, even as a supervision or a diversion. You know what you can never be?
A police officer.
A police
Oh
officer.
yeah, I saw that. I
Right.
totally did. I totally did.
And so that to me is problematic because we're forgetting the stupidity of people when they're 18 to 23 years of age because we don't make sound decisions.
And I've watched Keith. I didn't even cut you off, but
No,
this
you're
is
fine.
I've watched Deputy Keith Cross from APD talk about the lack of African American officers or people African Americans join the police force or people of color joining police forces.
Yes.
So look, I'm on the side of if you're going to complain about something, well, why don't you join?
Right.
If you got a problem with it, why don't you take the test?
Yeah.
I'm an advocate of that, and that's where I'm trying to forge that. That's where I'm coming from.
Yeah, and let me
Okay.
say this publicly, I need that at the state's attorney's office too. Because we don't have diversity at the state's attorney's office. And so I was looking at our resume book of the past people who've applied. And granted, they're not putting their race down, but I see a lot of people who are here from in this community. I don't see diversity in my office.
Right.
So I need diversity. So please, I have open spots. I need diverse attorneys applying
And
for
of
my
course, you have
job.
to have a law degree to work there. It's
Right.
incredibly difficult to hire a black police officer, to Deputy Chief Cross's point. And here's the cycle of historic issues. You have an antagonistic relationship with the majority of the community, I shouldn't say the majority of the community, with that community and law enforcement. So you already have that factor that doesn't want to engage with police and certainly doesn't want to work for them. And then because of our society and what we've created in the drug wars and the Bill Clinton Cops Grant and not funding low-income communities and giving them support, we have all these brilliant kids who were 18 to 23 and did something stupid, got that criminal history, that have black skin, and now that they're 25, 26, 30 years old, performing professionally wonderfully and would make outstanding police officers, not a chance, we can't hire them.
Right.
So that is a cycle that has created the lack of diversity within our staff.
Good morning, everybody. All right, so we'll take a. Let's move on to the next. I know we got another point to talk about. Because I looked at your. Let me get a.
We go for a 3-hour show here?
You know, let's we'll wrap it up. Damn it! This is too much fun. Yeah. Okay. Yeah. We'll do a part 3, part 4.
I knew this was gonna
You
happen.
put 2 politicians in front of a microphone at the same time,
Right.
it's gonna be a long show.
Because I want to pull up what you shared with me, Jamie. So give me just a moment here. I want to pull it up. Those points that you really articulated with force about the language, because people need to understand what language means when it comes to the law. But while I pulled that up, here's something that I found in the bill, and I want to get you guys'. All right. Enhances. I want to read a couple of things. Here's what the bill does. Enhances whistleblower protections. Extends all restrictions of the use of force that apply to law enforcement officers to bounty hunters as well. Now, this to me was. Bounty hunters are operating out there besides the standard.
No. We don't have bail bondsmen in Illinois.
So we don't have bounty hunters.
Yeah.
Okay.
Yeah.
So the whole idea of bail bondsman is a company puts up your bond for you.
Right.
And then if you don't show up, they have the ability to go out and get you. Dog the Bounty Hunter made that popular way back when.
Yeah.
We don't have that here.
Okay.
Yeah.
See, this is why it's good to see for all you people out there with the crazy this is why it's good to have law enforcement answering things for you. Expands the officer misconduct database and requires the maintenance of police misconduct records and requires use of special prosecutors in officer involved deaths. That's not already happening?
So one of the things that happened, and I want to look at kind of what happened with Cook County in terms of the whole, Cook County got off of the Jason Van Dyke case. And so they looked around to see who would take the case. The appellate prosecutor didn't, the attorney general's office didn't, so then they opened it up to all of the prosecutors, the state's attorneys.
Right.
Joe McMahon is the one who said yes. So again, kudos to him, he did it. So in officer-involved death cases, we have in Kane County a major crimes task force, which essentially is through our chiefs of police, and there's a statute specifically that talks about when and how this has to be investigated. And it has to be investigated not using the department who the officer is a part of. So let's talk about Aurora. Aurora has an officer-involved death. Aurora can't investigate that. This major crimes task force comes in and takes care of that.
Okay.
And so the state's attorney's office then is the one that is supposed to review those cases. What the statute does is it essentially says that if the state's attorney recuses himself or herself, or a court recuses that state's attorney, then you have to use a special prosecutor to do so.
Gotcha. I think a good place, we'll make this the last point, because this could go on forever.
It really could.
It really could. Creates new requirements in the event police execute no-knock warrants. This has been a hot button issue, including that 1, each participating member is assigned a body-worn camera and is following policies and procedures. 2, steps are taken in planning the search to ensure accuracy and plan for children or other vulnerable people on site.
Right.
And 3, if an officer becomes aware the search warrant was executed at an address, unit, or apartment different from the location listed on the warrant, that member will notify a supervisor who will ensure an internal investigation ensues. What's the process now for no-knock warrants?
So the process in the search warrant, in order to get a no-knock warrant, what the law enforcement has to do is say that there is a danger either to the community or to the police officers if they were to announce their presence ahead of time.
Right.
So
People on the run.
correct. I don't see this as being an issue at all, and I don't know that you have an objection to this portion because again, it's just adding a level of safety, especially for vulnerable individuals inside of a home. I don't ever search or serve any search warrants, so I'm going to defer to Sheriff Hain on this one.
Yeah, so as a 15-year narcotics investigator and a 15-plus-year SWAT team leader, I've done my fair share of search warrants. I am not a fan of any dynamic entry search warrant. That means knocking down a door and forcing a confrontation inside that house, you know, the way you see it on TV where police search warrant, boom, and then everybody runs in the house and everybody gets put down on their face and handcuffed. I'm not a fan of that. There's more than one way to skin a cat, as one of my favorite police commanders always says. And we serve search warrants. We make every attempt to serve a search warrant without any conflict. I don't want to give away all the tactics, but without breaking down the door and making that dynamic entry, because again, that forces a confrontation. In my 23 years of law enforcement, I have only served one no-knock warrant, and I wrote that warrant and got it, you know, and I served it myself. Got it signed by a judge, and we did a no-knock entry on somebody who was literally running guns. The only time I've ever charged somebody with the charge of gun running in my career, but he was selling, you know, multiple handguns and rifles, and this was truly a dangerous individual.
Yeah. Wow, that's interesting. So effective surveillance.
Yes.
It catches someone away from said residence. It's a
Perhaps.
much more, right, perhaps. We're not giving it away on the show.
And I can't wrap my head around, having served, man, hundreds of search warrants, how you hit the wrong house.
How does that happen? Yeah.
Well, I gotta tell you this, Google will take everybody to my neighbor's house, so that,
Yes, but police,
I know.
Right.
when they're involved in the investigation, they damn well better have eyes on that house on multiple occasions.
That's true.
To where they can describe it in their sleep, and then when they go to execute said warrant,
Yeah.
they better be able to lead that team up to said house to execute said warrant.
Right.
Okay, I'll give this one.
That's the way every proper procedure operates when it comes to the warrant service.
So it's 9:49 a.m. You guys have been watching and listening to Good Morning Aurora, the second largest city's first daily news podcast, and we're pleased to be discussing HB3653, the Police Reform Bill, not yet signed into law, with Jamie Mosser and Sheriff Hain. So I think to end, two things. One, what's engagement looking like with the sponsors of this bill? What's next with that? to speak to them and work with the lawmakers? Is that on the table?
Yeah, it really seems like where we are right now is working with our local legislators, who are reciprocating the engagement with us. There are a couple who are not reciprocating the engagement, with me at least, I won't speak for you.
Everybody likes me, so I'm
Yes.
getting reciprocation.
I'm a bit of a bull in a china shop, like I mentioned, so I'm sure I made somebody upset at me. Actually, I know I have.
Happens enough, right?
Yes.
Yes, actually, I know I have. So they are productive conversations, by and large. We just hope that they can carry that message back to the House floor and the Senate floor, and they can all meet in the middle. And we're relying on, I know I'm relying on our state sheriff's association, which I actually dissent from them on quite a few things that they oppose in this bill. I support. So I am relying on them to carry the overall message.
You know, I listen to you, Sheriff, and I watch what you're doing, and then I hear voices like who's the guy from the Chicago FOP?
I'll do it, yeah, don't even put me in the same room with that guy.
I mean, and I think that's a problem people have with this bill. I mean, how can there exist that
I'll let you describe.
ideology?
That's soft.
And, right?
Yeah.
That's the problem.
And that's been some of my concern with law enforcement through these conversations. Again, here goes the bull in the china shop. The Sheriff's Association will march, old white conservative sheriffs down there to engage with the Black Caucus, and they'll use examples like, well, hey, if you do this end-of-cash bail, we're gonna lose revenue and funding.
Right.
Guys, that's a horrible, horrible argument.
It doesn't seem like law enforcement, something that we talked about with laws, it doesn't seem like it doesn't seem like law enforcement as a profession of practice has evolved much in its way of thinking and practice. Not talking, the tech is great. The ability to stop crimes and intervene has definitely increased.
Yeah.
But it does not seem like the thought process behind policing has changed much from 1933, right?
But isn't that the laws that we created that's really doing that?
No,
Right. So
disagree.
in this bill,
A few times.
shocker, in this bill, does it say anything about what we should be doing with the individuals who we are detaining? No.
There's a little bit of stuff, rights for about people detaining and prisoner and citizen rights.
Right, so I'm talking, they're giving a lot of credit in sentencing, that's what they're doing, you're gonna get credit for it, but it's not really mandating. It's not mandating what Ron has done in his jail, that's what I wanna see. I wanna see us taking a proactive approach to actually getting to the root of the criminal justice problem. I want to see them actually deal with expungement and sealing laws. Why can't we expunge and seal a lot more? If you're found not guilty or a case is dismissed, that should automatically go off your record. Why do people have to go in and pay $232.57 in Kane County to file that to get it off your record? I think that there are a lot of common sense approaches that we can take to actually do what we're supposed to do to change policing, but it's going to mean, and is this the camera, is this camera?
Both.
Funding needs to be given to our social services agencies so that we can actually deal with the issues that we have, so that we have a place for people to go to receive treatment, so that people have a place to go when they lack resources, because all that we have right now is jail.
So you're halfway there, and I'll end with this. So this, and we keep pointing for those that are just listening.
Yeah.
This is, we keep pointing to the bill that Jamie brought, the big.
It looks like a telephone book for those who are not able to see it.
This is a paradigm shift, right? So you can enact laws that shift the paradigm. Now we have to worry about the mindset shift, which is your point. It's going to take a heck of a lot longer to get the mindsets of law enforcement to catch up with the direction of this bill. Even if we do all those wonderful things in funding, social services and mental health and whatever else, addiction counseling in the community. I'll give the example of my correction officers. When I took over as sheriff and I implemented all those programs right out of the gate, the officers joke with me now because they'll say, man, when you came in, you had about 10% of us that actually agreed with what you were trying to do and saw the future in it. And I said, well, how about now? Where are we at? And the answer has been unified. You're running about 60-70%. You're doing pretty good. That only took 2 years to start showing people, start proving people that this is how correction should be run. Now look at police officers looking at this bill and what this bill is trying to accomplish. So we have to help them shift in the direction that our society needs to head. And it's not an easy task.
And prosecutors.
That's your problem. That's not. Yes, your prosecutor. Actually, your prosecutors are my problem sometimes. So yes, that's what's going to take the longest to better our profession.
Ending thoughts to those people in the community who have reservations about the bill.
Who have reservations.
Mm-hmm.
So my ending thought is that it has a lot of good in it, and we need to push forward with it,
Mm-hmm.
but we need to do it in a way that actually does what it's intended to do, and we're ready and willing.
Correct. And from your exact perspective, the language in the bill in certain aspects of it is problematic and creates, or could create, bigger problems.
Yes.
Okay. And ending thoughts, Sheriff, on the bill?
Yeah, we're, as a sheriff, just like a state's attorney, have a great deal of autonomy, especially when it comes to protecting public safety in our community. If this bill is enacted, regardless of any changes, people should not be completely concerned because I'm going to do whatever it takes to keep our public safe. And that is, of course, within the law. Again, our policies, our procedures, our actions, our equipment mirror this new law almost to a T. What's going to be an interesting experience is the cashless bail system. We'll work together. We're poised with electronic monitoring. We'll keep tabs on people. We'll continue to provide counseling out in the community. We'll continue to provide those services that are unfunded, that should be funded by the state, to anybody that will engage in them. And hopefully the courts will help us mandate people to go to them. But as far as being scared or truly concerned about it, I don't think folks should really lose any sleep. We'll get this right.
Right.
And we'll do what it takes. If there's some things that aren't right, we'll do what it takes to protect our community.
I appreciate that, man. That's the message right there. Because, you know, I appreciate that because I have been overwhelmed and I've been looking like, man, how, you know, like, there's gotta be, you know what I'm saying? I'm sure that, you know, life will not turn to Terminator 2 when this, you know, Skynet and watch out, you know, people are gonna be eating rats and all that. So no, I do appreciate that. We appreciate you guys sitting down and talking to us, taking some time to explain the bill to ourselves and to all the listeners. So for all you listeners out there, you know, I don't care what link your grandma sent you to what website. You can get all of the facts and information here. This has been a great conversation with two of our great public servants, Sheriff Ron Hain and State's Attorney Jamie Mosser. This video will be up and it'll be on YouTube maybe tomorrow for those who want to listen. We appreciate the comments from all you guys, and from us to you, have a blessed, safe, and law-enforced Thursday. Don't break the law out there because they
Law enforcement support Thursday.
Yeah.
We'll come up with a new day.
There you go.
All right.